Okay, Marianne, good question. If you have a mediation agreement, resolution agreement, settlement agreement, doesn't matter, as part of a negotiated end to, let's say, a due process complaint, or let's say you ask for mediation, or even engaged in let's say, just sort of an out of the box informal discussion on compensatory services. All of those things, in my viewpoint, well, I mean, you sort of do need to have like a final order. There's some nuances in there, but you asked specifically for, let's say, a mediation. And I'm going to throw in there a resolution agreement or just a settlement agreement attached to a due process where a hearing officer was assigned. Let's nail it down, because those would be the same for all three. You can go back to mediation. You can jump straight to federal court for a violation, because the law specifically says that you can jump into state or federal court. But I wouldn't go to state court. Federal courts are more adept to handling this because they're more familiar with IDEA and special education laws, not the state courts. And then not only that, you'd have to file within your jurisdiction for the school system. And I wouldn't necessarily trust that, being that most state jurisdictional areas would be your county court, and most of our school districts are the largest employers, depending on where you're located in a lot of our rural counties. Okay. And you just don't want to get into that. So that's that. You ask to go back to mediation or file in federal court to compel. You can ask for a facilitated IEP meeting, and then have that brought up. And, that's a mechanism if you don't want to, go the route of asking for mediation again. But at the same time, if there are portions that haven't been followed, it doesn't matter. It doesn't matter whether they've done 5 things and they haven't done 2. It's an agreement. The 4 corners of that document is a contract, and it's different from an IEP. An IEP is a rolling contract that can be modified at various points by agreement of the IEP team. A mediation agreement is a legal document, and it's the 4 corners of the document. They agreed to do what was contained inside of it. And if you have problems in that area, then it just was one of those things to where you could go back to mediation. But if this is your second time around and they're not complying, then, you got to put some stank on it, or they're not going to take you serious. And this is where, using a specialized attorney like myself, or a specialized or very knowledgeable advocate like you, would be beneficial in helping the parent get corrective action, and then use that opportunity to also add whatever the current issues are within. So you excise the parts of the mediation agreement that haven't been done, and then you do a new analysis for the prior school year post the mediation agreement, to see if there's anything else that needs to be negotiated and fine-tuned and put in there, because that might be beneficial as well. But you might want to consider utilizing some additional help in that area if you're a parent faced with those kind of issues. Okay, good question.